Hi, everybody. This is Advocate Lucinda, your empowerment lawyer. Did you know that the state government, the federal government, does not have absolute sovereign immunity? This is true. And that's what we're going to talk about today. When the state government, when the federal government immunity is waived. And we're going to look at three instances when that happens. So let's get started. The 11th Amendment governs sovereign immunity. And I always like to give you the legal definition so that you can know it's legitimate. The judicial power of the United States shall not be construed to extend to any suit in law or equity commenced or prosecuted against one of the United States by citizens of another state or by citizens or subjects of any foreign state. So let's break that down. U.S. courts, and U.S. courts are those courts that are the trial courts of the United States federal judiciary. Those courts cannot hear cases and make decisions against a state if it is sued by a citizen who lives in another state or a person who lives in another country. The 11th Amendment has also been interpreted to mean that state courts do not have to hear certain suits against the state if those suits are based on federal law. There are three exceptions to the 11th Amendment, and that's what we're going to discuss today. One, waiver of immunity by a state's consent to suit. Two, an abrogation of the state's immunity by a valid act of Congress. And then three, the Exparte Young doctrine. So let's break them down. One, the state's consent to suit. A state may waive at its pleasure. A state may expressly consent to being sued in federal court by statute. So let's look at a case to illustrate this point. The case we're going to look at is Lapides versus Board of Regents, 535 U.S. 613, 2002. It's a consent voluntary litigation where the state waived its immunity by initiating or participating in litigation. So here are the facts. And in this case, Professor Lapides sued defendants, the state of Georgia Board of Regents. They allegedly violated state tort law and 42 U.S.C. section 1983, according to Professor Lapides, when they placed sexual harassment allegations in his personnel files. Professor Lapides sued in Georgia State Court, but the defendants removed the case to the federal district court, and after having done so, they sought a dismissal and claimed 11th Amendment immunity from suit in the federal court. And the defendants conceded that a Georgia state statute existed that waived its sovereign immunity from state lawsuits in state court. So there were appeals that led to the case ending up in the United States Supreme Court. The United States Supreme Court concluded that the university officials' voluntary removal of the action expressly invoked the jurisdiction of the federal court and thus constituted a waiver of sovereign immunity with regard to state law claims for which immunity was waived in state court. So, by the Georgia attorneys voluntarily moving the case to federal court, consented to be sued in federal court and lost its immunity. It's pretty clear, right? Okay, let's go to the next one. The second instance is abrogation or a repeal or abolish of a law by an act of Congress. Let's illustrate this. The federal government waived their sovereign immunity when it passed the Federal Tort Claims Act, which waived federal immunity for numerous types of tort claims. And of course, this is governed by the Legislative Reorganization Act of 1946. So let's see what the act entails and how it works. Under the Federal Tort Claims Act, the federal government acts as a self-insurer and recognizes liability for the negligent or wrongful acts or omissions of its employees acting within the scope of their official duties. So those official duties are the duties that a public employee is requested, required, or authorized to perform by a governmental entity. Keep that in mind. The United States is liable to the same extent an individual would be in like circumstances. The statute substitutes the United States as the defendant in the suit, and the United States, not the individual employee, bears any resulting liability. Now, the individuals who are injured or whose property is damaged by the wrongful negligence of the federal employee, again, acting in the scope of his or her official duties, may file a claim with the government for reimbursement for that injury or damage. Now, like any other litigation claim, there are elements that the injured individual must establish before they file the claim. So let's look at them. Showing number one. The individual must show that he or she was injured, the property was damaged by a federal government employee. Two, that at the time the government employee was acting within the scope of their official duties. That is really critical. That the employee was acting negligently or wrongfully. 4, that the negligent or wrongful act proximately caused the injury or damage of which the injured individual complains. So for each of these that I just mentioned, the claimant must provide documentation establishing that his or her claim satisfies all the elements of the Federal Tort Claims Act. So let's look at the third exception. The Exparte Young doctrine. I'm sure some of you have heard of this. In fact, I know because one of you asked me about this doctrine. The ex parte Young stands for the principle that sovereign immunity does not prevent people harmed by state agencies acting in violation of federal law from suing the officials in charge of the agencies in their individual capacity for injunctive relief. So let's illustrate this. Under Ex parte Young, federal courts allows suits against state officials acting on behalf of the state when the state violated federal law or the Constitution. And Ex parte Young is a 1908 case, landmark case, and you can read that at 209 US 123. So let's look at it in details. So the state of Minnesota, the legislature is the defendant. The legislature enacted regulating railroad rates, making it a crime if a railroad company charged rates in excess of the approved amount. And the shareholders of the railroad companies, who were the plaintiffs, became concerned. So the shareholders sued the state of Minnesota in federal court. They alleged the law that Minnesota legislatures just legislated violated the due process rights under the 14th Amendment of the United States Constitution. And of course, the 14th Amendment prohibits the government taking away the person's life, liberty, or property without due process. The shareholders also sued the railroad companies to prevent them from complying with the new legislation. Next, the Attorney General, who is also a defendant, filed a motion to dismiss based on the 11th Amendment prohibition against private actions against states. In other words, the Attorney General want the legislation to be enacted and law. As a result of the Attorney General's engagement, the shareholders sought an injunction against him to prevent him from enforcing the legislation. What a doozy, but a good demonstration. The circuit court dismissed the Attorney General's motion and entered a preliminary injunction to prevent him from enforcing the law. And the Supreme Court affirmed the decision of the Circuit Court for the District of Minnesota and held that sovereign immunity does not prevent individuals from suing government officials who attempt to enforce unconstitutional laws. Here's the takeaway here. The conclusion that there has been consent or a waiver is not lightly inferred. The court strictly construes statutes alleged to consent to suit. Consent isn't always obvious, but sometimes it's right there in your face. So you want to consider things like contracts. Read the contracts. Look at the employment contract, claims and clauses, insurance clauses. Sometimes this waiver or consent language is embedded in these documents. So keep that in mind. Of course, the injunction is an order by the court requiring a person to do something or cease from doing a certain thing. So I intend to get into the injunctions in the next video because there are three of them and you want to know them and just understand how they work. Okay? I trust this has been helpful to you. I am Advocate Lucinda, and we will see you next time. Take care.